So in this video, I have an update for you in 3 important Second Amendment cases currently up at the Supreme Court level, including the Duncan v. Bonta California magazine ban case, Bianchi v. Frosh assault weapons ban case, and the New York State Rifle and Pistol Association v. Bruen concealed carry case. So let's talk about this. But real quick before we jump into this video, if you think it's time for the Supreme Court to once again uphold our right to keep and bear arms, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main sponsors of this channel, which is USCCA. Through your membership, you get training, education, and self-defense and liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. Also want to mention that you can now pick up channel merch. If you're interested, you can use the link down below, and that's a great way to help support the channel. So I guess in the intro in this video, I want to give you guys an update in 3 important Second Amendment cases that are currently up at the Supreme Court level. These 3 cases are the Duncan v. Bonta California magazine ban case, Bianchi v. Frosh ban on so-called assault weapons in Maryland, and the New York State Rifle and Pistol Association v. Bruen, New York concealed carry case. So first, let's talk about Duncan v. Bonta. Duncan v. Bonta involves the possession of so-called large capacity magazines in the state of California. California Penal Code Section 32310 bans the buying, selling, possession, etc. of magazines that hold more than 10 rounds by ordinary citizens within the state. This law was challenged in the Southern District of California, and District Court Judge Roger T. Benitez, or Saint Benitez as he's known as, issued a ruling which found that this law in the state of California violated the Second Amendment. That decision led to what is called Freedom Week in the state of California, where during a single week period of time, millions of magazines were purchased and brought into the state of California. The state of California obviously didn't like that Benitez ruling, so they appealed that decision up to the Ninth Circuit. On review, a 3-judge panel in the Ninth Circuit agreed with Judge Benitez and his ruling. But again, the state of California didn't like losing, so they sought a rehearing en banc, which means a review by 11 judges in the Ninth Circuit. The en banc panel in the Ninth Circuit heard the case once again and issued their ruling finding that California's magazine ban does not violate the Second Amendment. In reaching that decision, they used their flawed 2-step approach and found that under intermediate scrutiny, the law was constitutional. The en banc panel therefore reversed the decision of Judge Benitez and essentially found that this law was valid since people had access to some sort of magazine to protect themselves. That decision by the en banc panel led to the plaintiffs in Duncan filing for a petition for Supreme Court review. In the petition, the plaintiffs first asked to have the Supreme Court address whether an outright magazine ban is a violation of the Second Amendment. Second, to decide whether a ban that requires people to turn over magazines to law enforcement and destroy them was actually a governmental taking. And finally, the plaintiffs requested that the Supreme Court review the Ninth Circuit incorrect 2-step approach and analysis that they tend to use to actually uphold these various Second Amendment violations. Now, the last time we talked about this case, I told you that the Duncan v. Bonta case was distributed to the Supreme Court for conference. What this means is that at conference, the Supreme Court and the justices get together, they review the briefs, review the papers, and they decide what they want to do with the case. Do they want to take it up? Do they want to deny review? Or they can put it on hold temporarily. Well, after the Duncan conference, we did not get an order from the court denying review in Duncan, and it was not redistributed for a new conference. And what that means is that the magazine ban case is now on hold until the Supreme Court decides the New York State Rifle and Pistol Association v. Bruen case. And the Supreme Court just did the same thing as Duncan in the Bianchi v. Frosh Maryland assault weapons ban case. Bianchi v. Frosh deals with the state of Maryland's ban on so-called assault weapons. Maryland bans the sale, transfer, or possession of semi-automatic centerfire rifles with detachable magazines and 2 offending features like a folding stock, grenade launcher, or flash suppressor. This Maryland law was challenged in a Maryland district court, and in the complaint, the plaintiffs conceded that the Second Amendment claim was foreclosed at the district court level based on a prior 4th Circuit decision on this very issue. A prior case, Colby, challenged Maryland's assault weapons ban, and on review, the en banc panel in the 4th Circuit in that Colby case upheld the state of Maryland's ban on so-called assault weapons, finding that these rifles are outside the protection of the Second Amendment because they are useful in military service. This case, Bianchi concedes that Colby is the controlling precedent in the 4th Circuit, but the plaintiffs in Bianchi contend that that decision was incorrect and is inconsistent with the Constitution and should be reversed by the Supreme Court. The question presented to the Supreme Court in Bianchi is whether the Constitution allows the government to prohibit law-abiding, responsible citizens from protecting themselves, their families, and their homes with a type of arms that are in common use for lawful purposes. Now, this case, Bianchi, like Duncan, was distributed to the Supreme Court for conference about a week ago, but when the Supreme Court orders came out, Bianchi was not denied review, and it was again not redistributed for conference, which means once again, the Supreme Court has placed the assault weapons ban case here, Bianchi, on hold until they decide the New York State Rifle and Pistol Association v. Bruen concealed carry case. So now we know two other major Second Amendment challenges, a magazine ban and a ban to so-called assault weapons, have been put on hold until the New York State Rifle and Pistol Association decision is issued by the Supreme Court. Now let's talk about that big case, which is the New York State Rifle and Pistol Association v. Bruen challenge to the state of New York's concealed carry laws and scheme. If you aren't aware, New York State Rifle and Pistol Association is a challenge to the state of New York's concealed carry permit requirements. The state requires a person to provide proper cause to be issued a permit to carry concealed. However, the issue is that the state of New York does not consider self-defense a proper cause, and therefore on that justification alone, people have permits denied. Essentially, a person in the state of New York has to distinguish themselves from the average person to be granted a permit to carry concealed. So the main thrust of this case is a challenge to the state of New York's May issue licensing scheme that does not treat self-defense as a good enough justification for a permit to be granted. This decision by the Supreme Court in Bruen will likely impact states like the state of New York and California, which use May issue licensing CCW schemes. However, this case will also have a larger impact beyond just concealed carry laws. Since this is one of the first major Second Amendment cases the Supreme Court has ruled on and will rule on in a very long time, the decision will impact other issues as well, like magazine bans and bans on so-called assault weapons and many more other issues as well. And that is why the Supreme Court has held both the Duncan and Bianchi case until they rule in this New York State Rifle and Pistol Association case. The fact that the Supreme Court is also putting all of these cases on hold, like the magazine ban case and the ban on so-called assault weapons, the fact that these are all being put on hold could also indicate that the Supreme Court was going to move on larger issues once they issued this one decision. Another thing we know is that either Justice Thomas or Amy Coney Barrett will be the author of the New York State Rifle and Pistol Association opinion. How do we know that? Well, because the Supreme Court operates in a way that shares the caseload when it writes opinions. For example, there were a number of cases that the Supreme Court heard last November, including this case, New York State Rifle and Pistol Association. Each justice takes one of the cases heard in any given month and writes the court's opinion. This leads to one opinion written by each justice per month. Now, for the month of November, there is only one case left, which is the New York State Rifle and Pistol Association case. And there are only two justices who have not authored an opinion for the month of November, and those justices are Justice Thomas and Amy Coney Barrett. Based on this facts, the odds are that Justice Thomas is the author of this opinion since he is the senior justice, and it's very unlikely that Amy Coney Barrett would author such a landmark decision. Now, when will the Supreme Court issue this opinion? That's one question I get asked quite frequently. What we do know is that the Supreme Court will need to issue this opinion at least by the end of June because that's when their session ends. So keep your eyes on at least by the end of June, but also we got another notification that the Supreme Court will be issuing more opinions this upcoming Monday. So keep your eyes on this Monday morning, however, since the Supreme Court will be issuing more opinions. If you see a Monday morning video from this channel, that means that the Supreme Court did issue that New York State Rifle and Pistol Association opinion. And another important thing to note with all of this is that the Supreme Court still has about 33 decisions that they need to issue by the end of this term. That would mean an average of at least 8 decisions per week going forward. So the Supreme Court will need to move at a crazy pace from here on out to get through the remaining opinions. And another thing to note is that there is still one major opinion out there, which is the Dobbs opinion, which was leaked, which deals with Roe v. Wade. That one's still out there, and the Supreme Court hasn't even issued that one. So there's going to be a lot going on here in the month of June. So 2 major Second Amendment cases have been placed on hold, and New York State Rifle and Pistol Association will be coming by the end of this month and could be as early as this Monday morning. So that's just a quick update on 3 major Second Amendment cases that are at the Supreme Court level. If you guys have any questions, go ahead and comment down below, and I'll try to answer the best of my ability. Also, if you like this video and like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algorithm rhythm. It adds fuel to his jet, and it signals to YouTube that you guys see value in these videos and in this type of 2-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And don't forget to stay with Built Bar Scholars, and the station will be maintained by Scholars.